Welcome and thank you for standing by. At this time, all participants are in a listen-only mode. If you would like to ask a question at any time throughout the duration of today's conference, you may press star 1 on your touch-tone phone and unmute your line and record your name. Today's conference is being recorded. If you have any objections, you may disconnect at this time. Now I will turn the meeting over to Ms. Janice Wingo with the International Trade Administration.
Good morning. Welcome to today's webinar on bad faith trademark filings in China. Today we're very lucky to have Joseph Simone, who's a partner at Baker McKenzie in Hong Kong. Joe has over 25 years experience in IP registration and enforcement, and I think we can gain some wonderful grains of wisdom from him. Mr. Simone has been very, very gracious to say he'd be willing to take questions during his presentation, and anybody who's listening on the audio cast, they can also email Mr. Simone. His email will be at the end of the program, and he said he'd be willing to take your questions as well. So, Joe?
Thanks a lot, Janice. Let me just delve right into it, and to simplify for those who are just interested in the top line, I've like to put the takeaways first, and we'll go into detail on a lot of these points. But in a nutshell, if you don't already know, piracy at the register is extremely common and fairly predictable even for small brands, in American brands, European, even for Chinese. It's a problem, a lack of certain provisions in the law, general lack of development in certain legal concepts, including that of bad faith, which I'll discuss a little bit more later. And it's kind of a reflection of the developing legal system in general in China. And it's also partly because there's a lot of enterprising folks there who just looking to take advantage of some weaknesses in the law, and it's kind of human nature, I guess, to a degree. Anyway, one must keep in mind this whole phenomenon that although you may be really very focused on your English mark, your English trademark, pirates are also going after your Chinese versions of your marks. They're going after logos and, of course, domain names and company names. So I'm going to just focus my discussion today on English, on the trademarks, which is the English Chinese marks and logos. It is possible once you find these marks to oppose them before they're registered in the gazettal phase and to cancel them after they're registered, but I won't go into too much detail on those procedures. I can provide some basic material on that if anybody would like. Standard memo stuff, but bottom line is, and we'll go into more detail on the basic Chinese laws on these. They can be used as a basis for opposing and canceling. But bottom line is, your outcomes most of the time are going to be uncertain. If you haven't already registered your mark in China, somebody's gotten there first. Probably means you haven't got a lot of use of your mark in China, a lot of advertising, sales, etc. And it probably means, and with the lack of that kind of reputation in China, it makes the outcome uncertain. And we'll discuss how to address that in just a moment. Next, the pirates. How can they hurt you? Well, they can stop you from selling. As a practical matter, a lot of people go ahead and sell anyway, and they take a lot of risk in doing so. But they can, go after you. They can go after your vendors in China. They can even threaten criminal action. So it's a serious situation for companies, particularly since I've been out here a long time. And when I started 20-something years ago, folks thought of China as like a third-tier market. Now it's the hope of the whole company. And so one plans ahead 5 to 10 years, even if today China isn't important, you'll probably be feeling it's important in 5 to 10 years. So again, pirates can stop you from selling, and it's something better dealt with earlier rather than later. Next, pirates can not just stop you from selling domestically in China. They can stop you from having your product produced in China for export back to the States or other countries. And this is probably the biggest concern that I see with SMEs, small, medium-sized companies from the U.S. and elsewhere. they have product produced in China, and they may do it directly, or they may do it through an intermediary, somebody in Hong Kong or Taiwan who arranges production in their factory in China. So there are consequences for when a pirate has a registration, and you may not be interested in selling, but you want to keep producing for export through your OEM suppliers. So this is another big risk, and it's another reason to really be focused on this sort of issue quickly, earlier rather than later. As I said, pirates can and do sue the owners of the real owners of the mark. So dealing with that kind of threat of litigation and trying to negotiate your way out of it and trying to resolve these disputes is part of what I want to discuss today. And there's some best practices I'd like to offer. And in a nutshell, for the best practices, I just list them out here as in this slide as file early and broadly. You're going to hear this from ITA, USPTO, all kinds of associations that whenever you hear about China, file early. It's a first-to-file system. There's lots of countries like that. China isn't unusual. Basically means whoever gets there first to the register has rights. Anybody who uses a mark earlier is not presumed to have any kind of rights. So, and prior use can be useful in an opposition or cancellation, but it's by no means a slam dunk. You'll have to produce more than just evidence of basic use. You have to generate a lot of evidence of reputation and other things. We'll get into that a little more later. Next, as I mentioned, pirates will go after a Chinese language mark, and a best practice for avoiding piracy is to create and register your own Chinese mark in China as early as possible. We found very recently in our firm that a few of the sort of smaller up-and-coming clothing brands in the U.S. Had been producing in China for a long time. They still have no interest in selling in China, not in the next few years, and they find that their brand has already been reported on in the Chinese financial press, and then eventually there's been mail order type sales, and when you do a search, you find that there's maybe 3 or 4 different Chinese versions of the brand already in circulation. The brand owner didn't even know about it. Well, very likely, in a situation like this, somebody in China is going to figure out not only that they should be registering the English mark, take advantage of a loophole, but one of these Chinese marks. So again, it's good to focus on Chinese branding earlier rather than later. Next is conduct a deep audit in all classes in China. It's not that hard. I'll explain how that can be done cheaply, and just do it on your own without even a lawyer helping. At least get yourself started in the process. But do an audit, and then if you find obvious problems, then get some advice and figure out what you need to do. Next is, after you've done your audit and you're up and running, keep on checking the register in China for pirates every 6 months. Maybe even every year, because applications can be detected while they're pending through online searches. There are watch services you can hire for this that are actually quite cost effective, but you can just get a lot more out of doing searches yourself, or having a lawyer or a trademark agency do such services. The watch services generally just they rely on kind of computerized, their own computerized system, which is just not entirely reliable. Finally, once you find that you've been pirated, it is important to look carefully at the options. And the first thing almost invariably we'll suggest is to investigate, have real investigators out there in the field, not just simple web searches or a D&B, but go out, have people in the field, and looking into the pirate and try to generate evidence that will help you figure out whether your legal strategies will work, whether oppositions or cancellations are more likely to succeed, or whether you're in trouble and you really need to look at other strategies like buying the mark, sitting down with the pirate somehow and negotiating. In some cases, we'll find that pirates get a mark and don't do anything with it, and then the mark expires after 10 years. So one strategy is to just sit and wait. We'll talk about the risks of that later on. If a mark is not used for 3 years after its registration, you can file a cancellation on that basis. That is a very cost-effective way of doing it, of dealing with pirates, but very often they will start using a mark to avoid its cancellation, to forestall that kind of cancellation. Next, as I mentioned, you can buy a mark. These days, for a typical SME brand, you might be, if you're lucky, you'll be able to buy a mark for as little as 15,000 US. But we're routinely dealing with cases where companies are required to fork out anywhere from 200,000 US dollars to $1.5 million US dollars. Sometimes it's even more, but those are usually for extremely famous brands. But for the normal SME brand where there's a significant market in China, already a lot of potential. Let's say the pirates will recognize that, and they will normally be able to squeeze somewhere in that range that I mentioned. And lastly, I did mention that you pirates can sue you, and sometimes you're going to want to sue them as well if they're using your mark. They might be using other parts of your intellectual property, designs or patents or whatever. Your battles with pirates will sometimes lead to real litigation, one way or the other, and those litigations can be extremely important for companies that are betting on the Chinese market, or where they're really are relying on their Chinese suppliers to keep exporting, product producing in China for export. So be ready for difficult litigation. It's not as expensive litigating as it is in the U.S. or certain other countries, but you want to bulk up on the right lawyers and investigators to make sure that you're getting all the advice you need. And so we call that sometimes bet the company litigation. Okay, let's take it from the beginning. The presentation, I'll take it from the fundamental elements here. Who are the key players I'll be talking about? The Trademark Office, like the USPTO in the U.S., it's under the SAIC. It's an administrative body. They handle oppositions and non-use cancellations in the first instance. Then there's another administrative body that handles appeals of the TMO's decisions, with a little bit more formality and review of evidence, exchange of evidence. So it's a little bit more careful handling of disputes by the Trademark Review and Adjudication Board, the TRAB. Then TRAB decisions can be reviewed by the #1 Intermediate Appeals Court, IP Tribunal. It is fairly conservative. It is only looking at whether the case was handled appropriately by the TRAB at the lower level. They will not really relitigate or reconsider every aspect of the case. Likewise, there's a final level of appeal, the Higher People's Court, which is also somewhat conservative. They generally, I think, about 80–90% of cases are just sustained at both of these court levels. And there is another level of, I wouldn't call it appeal, it's a request or a retrial request you can make to the Supreme People's Court. There are more and more of those cases. It is effectively another level of appeal, but you really only want to pursue that when there's a very distinct issue of law or very, very obvious problem with maybe misunderstanding of the facts, that sort of thing, or allegation of corruption, if you will, which is fairly rare, thankfully, in China. Here's I'm pulling up a slide now with provides general understanding of how applications are reviewed and the timelines. And so the timing for applications and oppositions and cancellations has swung wildly from fast and then to very, very slow, and now it's so subject to change. But right now it takes about 10 to 18 months to have an application examined, and then it's gazetted for a 3-month opposition period, and that's the period in which you can again file an opposition to the Trademark Office in the first instance. And then the Trademark Office will take usually 1 to 2 years to issue a decision, and the TRAB likewise about 1.5 to 2 years. And then the courts are sometimes going to be a bit faster in handling judicial appeals. So let's get in. That's the basics, some of the basic elements. Let's get into the subject matter here. What are bad faith filings? What kind of marks are we talking about here? well, we could have a pirate, registering an identical mark, or just some mark that seems somewhat similar with some letters changed, some very substantial variations, or it can be a mark that has the covers identical goods to those of interest to you, or just goods that are related or services that are related, and arguably could lead to consumer confusion if the marks are sufficiently similar. Then there's situations where the marks are filed for covering extremely different goods, entirely different goods or services. Those are more difficult cases because, particularly under Chinese law, they're very mechanical, generally very mechanical about whether there's the goods are similar or not, conflicting or not. There's a subclass index, and so if your goods are deemed dissimilar, that's generally it's not very easy to argue that they're related or like they are in the U.S. and other places. The good part of that is you get predictability at least. So bad faith filings happen in all these situations. I'll illustrate that in a minute, but before that I want to mention another type of unusual, but actually it's increasing phenomenon of pirates registering nicknames. Basically, foreign companies come in, they have their trademark, but then once it gets into the market, consumers, journalists come up with their own nickname for the brand. So, for example, the name Harley, as in Harley Davidson, has been just gotten into common usage, and somebody else, I believe, filed for that mark. And that had to be dealt with. Sony Ericsson's SWA-I in Chinese, same thing. And Pfizer's had the same issue with a Chinese version of Viagra. So these nicknames are something to keep an eye on once you've launched your product, to make sure that that there isn't such a nickname that's been adopted. If there is, you might want to file for it before any pirates do. I'm going to illustrate here one of the top 5 brands in terms of certain lists that we've been looking at of the most valuable U.S. brands. I guess Google is one of them. And we're just doing today a very simple search of identical marks in China, and we found filings by many different people for all kinds of goods and services. And the records indicate Google opposed all of these, and all of them seem so far have been rejected. But obviously, Google spent a lot of time and money dealing with those cases, and at least in the early days, they probably found that the cases were not all that easy to prevail in. But this, again, is an extremely famous mark, and generally China's been pretty good with protecting very famous marks, where the mark itself is highly distinctive. This next slide illustrates what happens with vis-a-vis similar marks. So you've got marks like Google Pad and GQQGLE, which of course looks like Google, and then you've got a whole bunch of marks here where the Chinese marks are filed together with the English, and there's a lot of variations of Google in Chinese, and that have been adopted by pirates. And there's a lot of questions you can ask about, should I go after all those? Well, in these cases, thankfully, each of the marks was filed with the English, so you didn't have to worry too much about the Chinese. But when a pirate goes after just the Chinese, you've got some interesting questions to answer about whether to spend on going after all the different variations. That's actually another presentation, dealing with Chinese language marks. But if anyone has questions about it, I'd be happy to answer. And then there's another little illustration of one particular serial pirate that we worked with or against for a client, Zhejiang Jialai Dunhua Sai. They filed for 164 marks we found, including a list of very famous automotive and heavy industry brands, and all in Class 7, which is for mechanical equipment. And so how do you search? How can you do it? Well, here's a website just on the screen here. You can do identical mark searches. You can do similar mark searches. And we've generally found the first place to go when you just want to scope things out is the identical mark search section. It's the second one down on the left, second click down on the left. Now, as you will, the next page is a sample of a page from a pirate's status file for one of its marks. And at the top left, you'll see there's an application registration number. It's in Chinese here, so but if you just familiarize yourself with these fields, you can find find it quite useful. Anyway, so you get the application date, the class, you've got the duration of the mark. You can see if it's been gazetted as registered, and then you have a notation whether it's been opposed or canceled. And then at the bottom right, you'll have this red letters, which invariably mean it's been rejected and invalid. So who are these pirates? Well, they're individuals, normally local. They're also individuals who set up local companies, usually very, very small, but not always. There's something called shadow companies. It's basically it's foreign companies or companies based in Hong Kong, which are used by Chinese individuals to file for these marks. What they do is often the shadow company, as we call them, will use the trademark in its company name, and then when the pirate wants to do business in China, he'll show up with using this front of a foreign company to make it look like they're associated or actually part of the legitimate trademark owner and his group. So this phenomenon was a lot hotter a few years ago. It seems to have dissipated to some extent, but it's something to be aware of. It also raises challenges about how to shut down company names overseas. Then there's the serial pirates who file for multiple famous brands. You've just seen an example just in a slide before. These are folks who are often warehousers of marks and trying to just sell them as a business in a very organized way. So what are the nefarious aims of these pirates? Well, very often they're not really trying to sell the mark to you or sue anybody. They're just trying to sell counterfeits. They will apply for the registration of the mark. They'll get a filing receipt from the trademark office, and then when they go around trying to sell their products, they use the filing receipt to suggest that they have illegal rights in the mark. And of course, a lot of people will not understand that the filing receipt is not a registration certificate. So that's one type of pirate. And very often they're filing for marks that are going to be rejected anyway. But so one has to distinguish this phenomenon from other types of piracy. The standard approach, however, is for pirates to file, and the idea that eventually the legitimate owner is going to come and try to buy and offer a lot of money to buy the mark. Sometimes these pirates are looking for commercial cooperation. They really think that by registering a mark, they'll be able to persuade you to do business with them. It happens. It's unbelievable, but it does happen, and I've only once or twice seen a client actually go into business with a pirate in a situation like this, and it's been very entertaining and disheartening at the same time. Anyway, the pirates will normally warehouse their marks again, waiting for you to come. But sometimes they will use a mark quite extensively, and sometimes engaging in what is best described as identity theft, meaning they've set up a company, retail locations. They borrow, they steal, designs, ad copy, company names, in order to really look like they're just part of the legitimate brand owner. And again, sometimes these are companies who perhaps naively think that they're just going to get bought out, not just the mark, but their whole business by the legitimate owner. Sometimes we find that pirates are increasingly using a mark at a very nominal level just to prevent their marks from being canceled for non-use, and to give leverage when they sue, because if you don't use a mark, the courts in China have recently adopted a policy where they're not going to give any or much compensation if the plaintiff doesn't show he's been using his mark to some extent. And again, some will will lie about, these pirates will lie during negotiations about their use, and it's sometimes hard to verify actual use, but they'll lie in order to leverage a better price. So what is the impact? As we said, it can block your rights to sell and license marks in China for domestic sales. And you've got the cost of oppositions and cancellations. You know, they can be as cheap as $500, $700 for very small trademark agencies who don't really invest a lot of effort. We have companies who end up doing 5, 10, 50, 100. Sometimes we've got some clients that are doing 500 oppositions a year in China, and then you've got appeals that you've got to deal with when you win, or when the other side challenges. The cost can add up dramatically, especially if you're going to be using a more sort of competent, legal advisors for this sort of work. You also have to deal with infringement claims, which, as you know, litigation can be trying, investigation costs, and then, of course, your company time, your management time. And then, of course, there's just the cost of buying a mark from a pirate, which, as I said, can be high. So these are significant costs that need to be considered in deciding whether to invest early in filing, because filing for marks is a insurance policy essentially. And one other thing, if somebody else has got a mark and your brand actually is known already, well, you might already be the victim of counterfeiting in China, and if somebody else has your mark, you're not going to be able to stop those counterfeiters that easily. So that's another important. But probably the thing that's gotten the most attention recently in legal circles out here in China is the developing law as it relates to the ability of companies to continue producing in China, even though another party, whether it's a pirate, bad faith pirate or not, but when another party owns the mark in China. So let's say you're arranging production in some factories in Guangzhou under decisions that go back to the early 2000s. Particularly, we refer to the Nike decision in Guangzhou in 2004. An OEM factory for another company that owned the mark in Spain, the Nike mark in Spain, was told, no, you can't produce in China. This is, by producing in China just for export, it's still an infringement of Nike's trademark registration in China. But there have been a couple of decisions coming out, particularly the Shanghai courts, but not only, but most famous one is referred to as the Zhoulida or Shenda decision, and there's been more recently Crocodile and a couple others. These cases seem to be reflecting a preference by judges and some policymakers in China to carve out an exception, much like Taiwan did in 2000, such that if you're just producing in China for export, it's not deemed to be an infringement. Why? Because, well, they say Chinese consumers are not being confused. And where the law is here is not settled yet. There's no trademark, there's no national law or binding Supreme Court opinion which would make this the law of the land, but there's the sense is that that courts are now, by and large, going to deem it not to be an infringement if you're producing in China, but you only for export back to some other countries where you own the mark, and where you're not selling those goods in China, there's no factory leakage, that sort of thing, and the supplier you have in China has done reasonable due diligence to ensure that that you do own the mark overseas, and to verify who owns the mark locally, etc. So the most interesting recent development is Chinese customs has now adopted this rule into such that if a pirate actually records with customs and wants to go after your OEM product leaving China, customs is going to leave it alone as long as you've satisfied these conditions. Unfortunately, we're dealing with some very intense cases right now where we found that local administrative enforcers, the AICs, the Administrations for Industry and Commerce, they are not respecting, they're following this customs policy. And I can tell you right now we've got cases where AICs have seized goods based on a complaint from the pirate, and it's very messy. So pirates can use the AICs and perhaps other authorities to stop your product. from being, from leaving the factory and getting to the overseas markets where you want it sold. So there's some very real risks. You can't just take these recent decisions, Shanda, Jolida, as a free pass to continue producing and export without fear of, of being sued and having your supply chain disrupted. So there are some strategies you can deal with. You can adopt for this, including going to court and asking for order of recognition of non-infringement. Now, due to time limits, I'm going to skip over a lot of the other material here. But next page here, coping with piracy is very important, as I mentioned, to investigate before you have a strategy. There are lots of investigators in China for IP cases. We are generally recommending that people hire the higher level investigators, more expensive, more sophisticated, more reliable, the people that you usually go to for fraud cases, that sort of thing, because these are just very important cases, obviously. It's important to investigate before you start approaching the other side with, to negotiate, because or before you file an opposition or cancellation, because the pirates will not be expecting the investigator, whereas if you approach them, then they will be on their guard for investigators. As I mentioned, you can just sit and wait and hope that a mark is just not used, or that the pirate goes bust. But it is a dangerous strategy, and because pirates generally are aware when they've got a valuable mark, and they'll follow the development of a brand over the internet, and so sit and wait strategies are not safe in our view. Where a pirate does threaten action, we would generally recommend a cancellation be filed as soon as possible after investigating, such that if the pirate comes after you, you can show you've already taken some step to stop him, and that will give the authorities that come after you, an extra reason not to delay or suspend their actions until the cancellation is decided. But they have the authority to just continue conducting seizures and imposing fines if they want to, notwithstanding the fact that you filed a cancellation. Just because you file a cancellation does not provide an automatic sort of free pass, or just give you more time to. They can take action directly. We would recommend normally that once you do file a cancellation, you approach customs and other authorities, including the courts in the regions where you have a factory in China, so that they'll understand what's going on in case the pirate comes and tries to just take action. But we generally suggest the strategies assume the worst, that a pirate is going to come after you, and prepare accordingly. With respect to negotiating, which is where most of the time these cases go, you will need to be ready for unmitigated greed by the pirates, moral insensitivity. They just don't get it. I mean, our sensibilities as Westerners are very different. They just look at this as a loophole in the law, and it's illegal for them to file until they're told otherwise. Be ready for that. Don't get too emotional when you see how they react. Don't get emotional when they ask for business cooperation. It seems naive and silly, but it's just par for the course, and just be ready for it. And be ready to pay. Just saying no, I'm not going to pay these guys, I'm going to let the legal process go, is delaying sometimes the inevitable, because if your lawyer's telling you your chance of success are not good, then it is probably better to pay earlier rather than later for any number of reasons. And lastly is be nice in negotiations, because in China there are cultural issues when negotiating, and even when you're dealing with somebody you think is horrible, well, they may not be that horrible, they just, in fact. And in any case, being nice is a good tactic, because in many societies, including China, if you turn ugly and confrontational and adversarial and aggressive, then it shuts down the channels of communication, and very often we've had delays of a year or two because simply the pirate didn't like the negotiator and how they were being treated, and whereas somebody else came later on, including perhaps somebody in senior management from the client, gave enough respect to the other side, and a deal was done within weeks. So these are important strategies to remember. Be nice. Okay, I've got a whole bunch of slides on the law. I just want to basically boil it down to, I mean, somewhat unstable, the state of the law, I have to say. But the current situation is that the if you're dealing with a bad faith mark, and you don't have any kind of significant fame and use of the mark in China, i.e. sales and advertising in China, before the filing date by the pirate. Okay, that means maybe two or more years before you find out about the matter or you've opposed the mark. If you don't have this kind of evidence, and there's a very good chance you're going to lose. And even if you might say, well, they copied my logo, they copied, my font, they've copied 2 or 3 of my marks, not just one. Generally speaking, people are really surprised when we tell them, you're probably going to lose, better to pay. Now, we do sometimes win on some of these cases, and we know the Trademark Office has been trying to loosen up and interpret their regulations and laws more flexibly. And so you might have some wins out there, and it's not as bad as it was, let's say, a year or 2 ago. But you need to assume, assume the worst for the most part. The cases where we are winning these days are generally based on this provision in Article 10(1)(8), which I will skip to now, where it basically just says that you cannot use a trademark which harms socialist morality or practices, or marks that have other adverse effects on society. Now, this provision is intended to protect the public good, but it has been used. The language in recent decisions refers specifically to confusion by consumers and the fact that a mark was famous, the overseas company's mark was famous. So it's very kind of, it's reassuring. There's very rare for these decisions to refer to the applicant, the pirate's bad faith, except where there's extremely egregious evidence, a very obvious evidence of serial piracy, like they filed for 300 marks, 200 marks, of all belonging to other famous brands. They seem still to be shying away from making determinations of what is bad faith and using that because, frankly, bad faith is not mentioned in the trademark law directly as a basis, and that is one of the main problems we're having right now. But they're trying to do their best at the Trademark Office level. I'm going to click through to just a couple other best practices and then open up some questions. So for the oppositions and cancellations, if you can get evidence that the pirate knew your distributor or OEM supplier or had some direct business dealings, this is golden evidence because there are separate provisions in the law on this. It's very hard to find this in most cases, but it's worth fishing for it. Otherwise, you would try to argue your mark is well known because that, that's a term of art, which is kind of like the highest level of fame, but that really only applies to extremely well-known brands, and the Chinese are reluctant these days to designate a mark as well known because all kinds of reasons. But one of them is they found, I think, too much bribery among the Chinese brands of Chinese officials to get well-known status. A lot of that's done for marketing reasons because once they hear the government has recognized you as well-known, it's considered a marketing plus. So they will look for other ways to give you the kind of protection that they think you deserve, other than calling it well-known. Again, maybe using Article 10(1)(8) of the trademark law. Illustrate in your arguments your company's benefits to China, how many people you've hired, either directly or indirectly, any CSR of activities, charity donations, and that sort of thing. Present the best evidence of bad faith available. This is, as I said, bad faith isn't really directly mentioned in the law, but there are drafts of the law, of an amendment to the law, which are circulating, which would recognize bad faith as a independent grounds for dealing with bad faith piracy. So, once they change the law, it would probably be used retroactively. Usually, in these situations, it would be. It also that whatever evidence of bad faith you gather can have indirect influence on the examiners. They're not they're not just going to ignore it entirely. So if infringements are ongoing by the pirate, consider going to court. Maybe you'll have a basis for going after them under unfair competition or some other grounds. Maybe they're infringing other IP. And once you get a judge involved, even peripherally, the TMO and the TRAB will usually want to hear what the judge has to say and be guided by the court, because in fact the courts trump the administrative authorities in general for these sort of things. But the judges that deal with any kind of infringement case cannot direct the TMO or the TRAB to decide an opposition or cancellation in one way or the other. And obviously if you can get evidence of actual confusion, that's wonderful. Lastly, I've put in some policy recommendations. I work with a bunch of industry associations that have put together comments for the Chinese legislature and the TMO about how to amend the law to deal with more effectively with and how to deter bad faith piracy, and as well as deal with existing cases. And so I've listed a bunch of things out here which are based on international practice. I won't go into them, but they're there for your viewing pleasure. Some of the recommendations are on this last page are suggestions on how the law can be interpreted under the current law in a way that is perhaps a bit more creative. These are things that you might want to address in your arguments, that you're filing. So thank you very much. I'm done with my prepared remarks. Any questions?
At this time, if you would like to ask a question, please press star 1 on your touch-tone phone. You will be prompted to record your name. Please unmute your line and do so when prompted. To withdraw your request, you may press star 2. Again, to ask your question, please press star 1 at this time. One moment, please.
Thank you again, Joe. I know that there's some people who are listening who may have some questions that they might want to email you privately. If you would like to do so, you can email Joe at jts@bakermckenzie.com. This is also for people listening to the audio recording. He said he'd be happy to answer your questions.
And we do have a few questions that have come in. Keith Park, your line is open.
That the evidence of use, if trademark squatter, our company, has this problem in China, and they license the trademark. Supposedly you can record licensing the trademark. The trademark squatter has registered in China. Is that regarded as a use of evidence in China, even though the licensee has not produced any products, also has not commercially sold the products?
That's a good question. There aren't that many cases like that come up, and when I've inquired about that myself, I've had over the last 20 years, I've had different answers to the question, but the trend is not to recognize a mere licensing as use if it's quite clear that the licensee is not about to start using the mark. I mean, they're looking at substance here more and more. So if it was done, for example, just for the purpose, if the license was put in place and recorded just for the purpose of preserving a registration, protecting it from a cancellation, you'd have a better basis, more confidence that you'd be able to resist, that you'd be able to prevail in a non-use cancellation. But that's another reason, again, to investigate deeply. There's China's a civil law country, so decisions can go both ways. There's a lot of discretion. So I'm afraid there's no simple answer except for that there's a trend in the positive direction for this, but you need to argue it and get as much evidence as you can to show it's not bona fide, use, if you will.
Thank you.
Carla Kuhn, you may ask your question.
My question is, what about opposing an application in a class that is different from the one where the trademark owner's activities are principally involved. In other words, what are the chances of success, and what do you need to succeed to oppose the registration of your mark in an unrelated class?
Good question. Generally, you start with this basic concept that you'll lose, okay, unless your mark is deemed well known in China. So, and that's just going to be very rare. There's only, a few hundred marks recognized as well known in any given year. There might be 80 or so marks. I think there's now even a quota system. They're just trying to limit the number of Chinese and foreign marks. With that said, as I mentioned in my presentation, there have been cases where a mark is deemed to meet a certain level of fame, and where the TMO regards that there's a real risk of confusion. All right, there are more and more decisions where they are actually protecting against vis-a-vis dissimilar goods and services. So it's happening, but it's not. Generally speaking, when you've been pirated.
Yeah.
I mean, the cases we're dealing with, it's just there's not that kind of evidence of fame, or maybe the mark is not distinctive, as highly distinctive, or maybe there isn't enough evidence of bad faith such that the examiner really wants to go there, and use Article 1018. So again, that would be a situation where our basic advice would be, if it's annoying, if this mark is annoying, you really don't want it to be used by somebody else, but you're not ready to spend money for it, then just to oppose, okay, file the opposition, even if you spend very limited money on it in terms of developing arguments and evidence. That will at least delay the registration of the mark for 2 years, and if you appeal, maybe another 2 years. And often during that period, the pirate will just kind of lose interest, and so that is a very practical strategy. And if you lose those cases, you're not required to compensate the winner's legal fees or anything. So there's really no downside. There's no risk in simply filing a simple, opposition.
Right. And did I hear you say that if a pirate offers to sell you the mark for $15,000 US, that's an okay price, even if in an unrelated class?
Well, that would be a situation that where 15,000 might be on the high side, but it's going to depend on the goods and the mark and the fame. And now, very often, one of the strategies we use to buy such marks, even if it's in an important class, is we have the investigator the investigator set up a front company, and then he will approach the pirate, not in the trademark owner's name, but in the name of essentially, pretending to be another pirate.
Right.
So, and we've been able to get those marks, and things have gone smoothly. We haven't had pirates come back and challenge the transfer on the basis that we didn't disclose who we were, that he was tricked by the investigator.
Yeah, good point. Going back to the deemed well-known mark in China, I've tried many times through local lawyers, and I've never been able to get our clients' marks recognized as well-known. So it seems like a very difficult hurdle, and you can only try to get your mark recognized as well-known in the context of an opposition. You can't just apply to have it recognized as well-known. Is that correct?
Well, opposition, cancellation, you can do infringement actions as well, but you cannot just simply ask for that kind of recognition outside of the context of some kind of dispute, basically.
Right, and is there any kind of guideline as to when you might be able to get your mark recognized, as the amount of evidence that's required for recognition of the mark as well known?
Well, there's a list of suggested items that there are guidelines on that. You don't have to provide everything, but we generally do find that they will expect a certain amount of certain types of material, invoices, tax receipts, whatever, things that they are used to seeing. So this is just some know-how that a lot of times the Chinese agents will give you the list, and then you just say, well, I can't give this, and then they won't push back and say, no, you really need to give us this, this, at least this stuff. So there's and generally speaking, even if your chances of getting well in status, they're low, by going through that effort, pulling all that material together, it does have an impact on the perception of the examiners. So I wouldn't, and as we said, you can still get the same protection vis-a-vis the similar goods under Article 10.1.8 these days. I wouldn't say that a year or two ago, but we're getting that now. Okay. So, and not in all cases by any means. There seem to be, but at least in cases where you might think, well, so my mark is well known in the U.S., right? And there has been some significant use in China, and those are cases where, again, you're more likely to have a fighting chance under 10.1.8.
Okay, and if I may ask one more follow-up question, you indicated that an investigation should be done by people who are prepared rather than just some internet search. And I was wondering, what is the average cost of an investigation that would then prompt the AIC to raid a factory? Is there some?
My focus on investigators and my comments before was really much more on preparing a strategy for dealing with a bad faith pirate. Okay. Because you want to get evidence of connection, with maybe some indirect connection, et cetera. Evidence, maybe oral admissions of copying, of knowledge of the brand, infringement of other rights, et cetera. So you might want to. That's why we suggest going after for high-level investigators for that. Now, those kind of high-level investigators, who will also be generating evidence, obviously, of any infringement that could permit, a civil action or AIC action. Those guys, I would normally tell clients, $15,000 minimum, off 15 to maybe 50,000 if they have to do 2 or 3 waves of, inquiries. For your standard IP investigator in China, you can get them in the field doing, basic work for $1,500 to $3,000 US. Okay. That's what we're used to paying, but it's the same old. You pay peanuts, you get monkeys, sort of thing. Not that my investigators are monkeys, but you're just not getting the sort of time and sort of know-how as you would with the higher level investigators.
Right. Okay. Thank you very much.
Mm-hmm.
Bill Brandt, you may ask your questions.
Thank you. Thanks so much, Joe, for your presentation. I really appreciate it. Can you hear me okay?
Yeah, sure.
Okay. Great, thanks. One of the things that we've encountered with some of my clients is actually pirates filing the logos that we have copyright protected in the U.S. I've had some difficulty getting reciprocal recognition, even though China's a member of the Berne Convention. I've actually had some decisions that indicate that the copyright wasn't used in connection with the particular filed goods. Have you had any experience with this? And do you recommend filing copyrights actually in China, even though you have U.S. registered copyrights?
That's interesting. There might be a communication issue here because generally when clients say the first half of what you're saying, what's happened is that the evidence of copyright ownership was not in a form that the Trademark Office felt comfortable with. And you don't need to actually register, your copyright with the National Copyright Administration of China. They do have a registration system in China. Generally, they will be happy at the Trademark Office with a U.S. copyright registration, provided it's you've processed it, notarized, legalized, whatever that's necessary. Right. And sometimes, just the paperwork that's the supporting paperwork is otherwise incomplete. So it's very case specific, but if the work itself is, they like U.S. copyright registrations because they know that the U.S. Copyright Office does examination for originality. And in China, actually, we've gotten copyright registrations for things which would never be registered in the U.S. So then they respect the U.S. registrations. If you really need to pile on, because again, these officials have a lot of discretion, and it's really important to client, then go ahead and register in China too. It costs a lot more than in the U.S. in fact. But generally the U.S. you should be fine. And your point about different goods and all that, that sounds strange because generally a copyright is a copyright, and it has nothing to do with the goods. So they may have made a mistake. It sounds like either a mistake in the law or maybe there's the decision may have been reported wrong or interpreted wrong.
Well, we're appealing it now. In fact, but how about, and also one of the things I was wondering too, thank you for that, but how about industrial designs, filing industrial design applications in China?
Well, when you mention that, the most common situation we have is where a pirate has also gotten a design patent in China, and they try to use that. And generally speaking, the authorities ignore those because they're not examined, and usually the dates don't work up. They're not actually. I generally just ignore design patents for all these purposes. I don't think clients should go after them unless they want to, use them offensively in against design infringers. It hasn't really been that relevant to any trademark registry disputes.
Okay, thank you.
Sure.
At this time, we have no further questions.
Great. Time for bed.
Yeah, it is quite late in Hong Kong. Joe, thank you again for your time. I just wanted to remind people who may be listening on the audio recording that if you do have any questions for Joe, you can reach him at jts@bakermckenzie.com. I also want to let people know that on August 17th, we will have a presentation on patents. It's a very basic presentation on patents for business people and people who may not like file in China but who instruct Chinese patent attorneys. It's going to be given by a Chinese patent attorney who has an LLM here in the United States. That's on the 17th. And you can check the stopfakes.gov website to see the time. Again, thanks again, Joe.
My pleasure. Cheers.
This concludes today's conference. Thank you for your participation. You may disconnect at this time.